Good afternoon, everybody.
Good afternoon.
Hey, you don't get that kind of response every day. I love it. Thank you. Thank you all for being here. What a big crowd. We don't usually have this kind of crowd at 1 o'clock on a Wednesday afternoon. So thank you all for taking your time for being here. I understand this is you're demonstrating that this is a matter of importance and concern to members of the public. So thank you for being engaged. My name is Ryan Dorsey. I am the chair of the Charter Review Special Committee. We're joined today by Vice Chair of the committee, Councilman John Bullock.
Thank you, Mr. Chair.
To my far left, Councilman Zach Blanchard. To my far right, Councilwoman Odette Ramos. To her left, Councilman Jermaine Jones, all members of the committee. Council President Zeke Cohen is here with us, will be with us for the beginning of the hearing today. Thank you for being here, Mr. President. We have our committee staff member to my right, Mr. Ethan Navarre. Hello, Ethan, how are you today?
Wonderful, Mr. Chair.
He's wonderful, in case he doesn't have a microphone. He's wonderful, though. We have representatives from a plethora of city agencies. Thank you all for being here. The Mayor's Office, Law Department, Inspector General's Office, Department of Legislative Reference, Ethics Board, Finance, and we have the bill sponsor, Councilman Mark Conway here. He's going to present the bill from the podium here in just a second. Just as a matter of run of show, what we will do is we will hear from the bill sponsor, and then we will hear agency reports from the agencies who were requested to report on the bill. I'll give them 5 minutes each. Then once we've heard from the bill sponsor and the agencies, the committee will have questions throughout the hearing today. I will recognize people in order to allow them the opportunity to speak. And when we come to public testimony, everybody who wishes to testify will be called in the order in which they signed up on the sign-in sheet outside. If you wish to testify, please be sure to sign that sign-in sheet. I will recognize the people who have signed up and not others. We will hear from the council president who wishes to make some welcoming introductory remarks before we go to the bill sponsor. I think that covers everything preliminary. So Mr. Council President.
Thank you, Mr. Chair. Thank you to everyone who has shown up today. Thank you to all the agencies, the Inspector General, to all the folks in the public. And apologies, I am gonna have to leave pretty soon after, but did want to just welcome everyone here today and acknowledge this is an important topic for the city of Baltimore. As Council President, I have stressed the importance of oversight and transparency and appreciate efforts in that direction. This is a complex matter. I know we're gonna hear, in addition to the bill sponsor, from the Law Department, from the Inspector General, from all of the parties that are here today. And I think it is important to acknowledge that as a city government, we believe strongly in transparency, in access to information, and in real oversight that is meaningful. I also know that this committee, and I want to sincerely thank the entire committee, has been doing an extraordinarily deliberative job. There is a package of bills that these folks have been feverishly working on. This is not one of them. This is a new bill, but I will just acknowledge that this committee, the Charter Review Committee, has been incredibly deliberative and diligent in its work. And so I am grateful to get to be with you all here at the start. And with that, I will turn it back to you, Mr. Chair.
Thank you. Councilman Conway.
Thank you, Mr. Chair. First, I want to thank you for, getting this hearing on the books, loading the limited amount of time that we have to consider the bill in front of us. Yes, it is a complicated one, Mr. President, and I want to make sure we make the right decision here. This is a critical backbone for accountability, transparency, preventing fraud here in the city, and I know we all want to support our Inspector General or Inspector Generals into the future. So I will start first by talking about a little bit of the background, how we got here, the issue that I think brought us to where we are today. Last week, we had a hearing about the Sidestep program in Muncie. I won't bore you with all the details. I'll just give you the highlights because I think it is important in helping everyone understand the importance of the IG's office and the work that they do. In that hearing last week, we heard from Muncie, we heard from the IG, and we learned a couple things. First, we learned that the Sidestep program, which is the youth diversion program, geared towards supporting young people when they make mistakes, had issues with data and accountability. There were basic problems with the program. They didn't have a good sense of how many kids were referred to the program. One said 55, another said 51. Less than half of the kids in the program actually had any notes about what they'd done. So there was a huge issue there. And then nearly a third had no recorded outcome at all. And so, one, data was a big issue. The city paid for an outside evaluator, $25,000 to do an evaluation of the program. And I'll read you a little bit of what they said. They said, what has become clear from the conversations with the service providers is that Sidestep is not implementing, at least to the extent of the information that has been provided, a standardized structured process and system to A, document the diversion work of the service providers, and B, measure the outcomes for effectiveness. Without the enforcement of clearly established metrics and benchmarks by which to evaluate the progress and effectiveness of all aspects of the program, Sidestep's diversion efforts are not quantified. This is important for two reasons. We learned over the course of the last year, this report came out in 2023. In 2024 and 2025, the administration intended to expand that program. It was only focused in the Western District, and it was going to be expanded citywide. It's important for a second reason as well, because we know that there was fraud in the program. We found that the Inspector General looked into the program and gotten some files. She had this access that we are here today to discuss, and found that there was fraud in the program. In the middle of that investigation, her access was pulled. She no longer had direct access to those files, and when she subpoenaed those files, she got over 200 pages of redacted files, Cash App payments that were completely blacked out, and we could not tell where the city was spending money. For many reasons, that's absurd to me, at least. Nonetheless, she still found fraud, thousands of dollars of fraud, tax dollars, misspent. Now, why is this a problem? For obvious reasons, it's fraud. Obvious reasons, we weren't tracking information. Obvious reasons, there were kids not getting the services that they needed. This program was broken, and we didn't know it. We as a council had no idea. There was a whole report done on this, and we had no idea as a council. The only reason we knew about this was because the Inspector General did a report. The only reason that Muncie knew about some of the problems in the program was because the Inspector General did a report. I asked in the midst of that hearing whether or not the Muncie director found the report helpful. She unequivocally said yes. I asked her if she would have known any of those things without the Inspector General's report, and she said no. So I just wanted, this is the foundation from which we're working from. The Inspector General really helps us to be a better city. She helps us to correct problems. She helps us to identify issues. So the bill. This bill is incredibly simple. We have an amendment for the bill in anticipation from pushback from the law department. And I will preface this. I think our law department has a conflict of interest here. The law department is not only arguing in court against giving access to our Inspector General in order to further investigate the fraud that we know of, but our law department is effectively, and we all know this, first acts on behalf of the mayor's office. And so they don't necessarily want to see this information come out. This is why we made the Inspector General an independent office, because previously the Inspector General was part of the law department. And we knew that there was going to be friction sometimes. Sometimes an administration would not want the Inspector General to inspect certain things or put out certain reports. But our priority here is transparency. Our priority here is accountability. And I want to urge you, as you consider the law department, which I've spoken to some of you, I understand is troubling for you that the law department has come out against this, but we have voted against the law department's reports in the past. The youth fund would not exist without the council voting over the law department. Body cameras for our police department would not exist without the council voting over the law department. So this would not be the first time that we did not vote against the law department. The bill is very simple. The bill does two things. And I'll just read the line, the only line that really matters. It says, it adds to the charter that the mayor shall promptly facilitate the transmission of records to the office of the Inspector General as an authorized individual as described in the Maryland Public Information Act. So it literally it points to state law. It points to state law and says, do that. It's just that simple. The second piece of it is, I understand the concern of maybe the law department or others is that we might disclose or release information that is sensitive and should not go out to the public. That is a very reasonable concern. And so what I did is I put an amendment in here that says that the advisory board for the Inspector General shall select a qualified designee to review the investigation reports from the Inspector General prior to their publication and ensure necessary redactions of sensitive information have been made in accordance with the state and federal law. Once again, pointing to state law and saying, do that. This is actually very, very simple. I want to acknowledge one more thing before I close up. I understand this is a highly political bill. I understand you guys are being asked to do something that our mayor may not want to do, but that is our job. Our job is to do what is right on behalf of the citizens of Baltimore. And I wouldn't be doing this if I didn't think it was in the best interest of Baltimore. We have an interest here in making sure that we are not just protecting the interests of whoever has defrauded the city, but we are also protecting the interests of our children. The folks who were supposed to go through this program and get services that did not get those services or did not get sufficient services or had invoices paid on their behalf that didn't actually result in service. So we know that in the Inspector General's report, she said that this issue has already been referred for a criminal investigation. I urge you to consider that regardless of what you do today, this will come out. And we will look back in whatever number of months and people are gonna ask how you voted. Please make the right decision. Just please make the right decision. I don't know what you guys think about me or the bill or the mayor or whatever the case is. Make the right decision. Thank you.
Thank you. Thank you. Okay, thank you. We will hear from the agencies to whom this bill was referred, starting with the Office of the Inspector General.
Good afternoon, Honorable Chairman Dorsey and Council. Thank you very much for giving us the opportunity to be here today. I am the Inspector General, but this is about the Office of the Inspector General. So I'm going to let my deputy, Matthew Neal, born and raised in Baltimore, talk deeply about what he feels about this bill. So I'm turning this over to him.
Good afternoon, Chairman Dorsey and honorable council members. We are here today before this honorable committee because our office is at a critical juncture, which, without action, would have devastating consequences for our staff's ability to do their jobs. Our job is to investigate fraud, waste, and abuse while promoting efficiency, accountability, and integrity in the government. This honorable body has been there for our office in the past. We are grateful for Councilman Dorsey, who in 2018 introduced the bill to give the citizens an independent investigative body, and it passed with 79% of the citizens' vote. It was other council members, including Mayor Scott in 2020, who introduced a bill allowing the Inspector General to bring a report to City Council for the removal of an elected official. That passed with 91.5% of the people's vote. And the office was provided stronger independence when Councilwoman Ramos put forth a bill to change the OIG's advisory board from elected officials to a citizen-based board, and that passed with 86% of the vote. We are not just here for our office and the taxpayers today. We are here on behalf of those who will come after us. In our office, this government, and those citizens who are not yet paying taxes, but one day will and will deserve an effective oversight and review agency. Our city has existed for centuries and will continue for many more. While we are all fortunate to work in this remarkable government, our time here is merely a blink in the eyes of our citizens. Nevertheless, the decisions made here hold great power and can have lasting effects. The employees in our office are humble public servants that pride themselves on being thorough, accurate, and objective. We truly love this city and work meticulously to provide reports to leadership that could affect positive change. Our office and employees have continued working under an incredible amount of stress and pressure. For decades, this Inspector General and those before her have had direct access to records. This means having policy and procedures for access to documents such as email correspondence, invoices, timesheets, and pay records. The necessity for direct access is multi-layered. We cannot investigate in a timely manner as the OIG currently has 18 outstanding subpoenas, most from March, that we have not received documents for. This is impacting our agents' ability to conduct their investigations. Hundreds of prior investigations we have completed and a total of $40 million of identified waste or fraud would have been impacted under this new approach. We spoke with Baltimore County, Montgomery County, and the DC Inspector Generals and learned they are not required to have their email requests be reviewed by their law departments. This review breaches the confidentiality of our investigations. These documents and email correspondence the office seeks access to do not belong to any one individual. My emails and your emails do not belong to us. All of our emails are city property on city devices paid for by the taxpayers. This is clearly spelled out in the city's administrative manual and technology policy, which all employees sign and are provided notice when logging onto their computers. Access to these documents was reinforced at one point by a prior city solicitor to the IT department. Further, the OIG cannot ensure the reports are accurate if information is limited or redacted. Most importantly, the OIG cannot independently or accurately corroborate witness statements or confirm the authenticity of financial documents if the OIG is forced to subpoena third parties only. To not allow the OIG to see the actual documents that city employees viewed to approve payment is the opposite of what this office is supposed to do. We are supposed to inspect the work done within city government. We are not asking for any more access than what the city has given our office the last 2 decades. The question is, what has changed? Before the OIG's document request to a mayoral office, the OIG had never received redacted records. Then, on the night of January 23rd, a midnight move occurred, reminiscent of the Baltimore Colts being taken away by Mayflower trucks during a snowstorm. This move involved the city compromising the OIG servers, and just like that, our access was gone, and the city's data and records were moved behind a wall. Most importantly, too, we can't protect those who have brought us complaints previously because we do not know who is accessing our server. Those complainants range from elected officials to employees who fear retaliation and everyday citizens. There are concerns about this bill not being legally sufficient, according to the law department, who is the same agency that has taken adverse actions against our office recently.
Oh, I will ask you to try to wrap it up here.
Okay.
I gave everybody a 5-minute time limit.
Okay, I have more, but I'll do my best. This is not the first time. The bill I mentioned from 2020 involving allowing the Inspector General to move forward with a report to City Council to remove an elected official. The signed ordinance for that bill, which I have here today, states this bill is not approved by law, yet it became a charter amendment because council approved it and citizens voted 91% to approve it. Council has not allowed the law department to stop them from doing the right thing before, and I hope that is not the case here today. It is our office that is targeted with this new interpretation of MPIA today. Tomorrow, it could be City Council, audits, or any other city agency. If no one is able to view the necessary city documents and provide oversight, who will? Transparency is a word that is used freely at times to describe beliefs and intentions, especially when discussing the Inspector General's access. However, words without action are just manipulation. Do we want a Baltimore city government without oversight? That is what is at risk. Any suggestion that is less than that is minimizing the issue at hand. We have seen Inspector Generals targeted and removed at the national level. In Baltimore, mayors have removed 3 of the last 4 Inspector Generals. An essential tenet of government is that it exists to help people. Our agents and I have sat in interviews with employees and citizens who are brought to tears when describing situations they are facing. They turn to us for help as a last resort. We can no longer help with a thorough investigation if we do not have direct access.
Okay, I need you to wrap it up.
All right, we have one more paragraph and then
One more paragraph.
Yeah, I promise you, I'm sorry.
How long a paragraph is it?
Short.
Thank you.
I'll read quickly. No longer able to help those men and women in the Department of Public Works. No longer able to help the janitorial staff in City Hall who were not paid their wages until our office's investigation. Not able to protect the person who warned us about the city's water almost reaching a Flint, Michigan-like crisis. Those are the people I think of when I remind myself why our office does what we do. They risked everything to speak up for the right thing. Now the question is brought forward to this venue. Will this committee and this city council allow for the right thing to be done? To allow the public to vote on having an effective Inspector General? We respectfully request the council to act by forwarding this bill out of committee and eventually to the voters who we all work for. I'm truly grateful for the opportunity to speak on behalf of our office and employees today in front of this honorable body. Thank you.
I don't see a report from the city administrator.
Good afternoon, Mr. Chair. So Nina Themelis, Director of Government Relations for the Mayor's Office. The City Administrator defers to the position of the Law Department, supports the role and the work of the Office of the Inspector General, but does not have a separate report at this time.
Thank you. I will go to the Department of Legislative Reference.
Good afternoon, Mr. Chair. Ben Guthorn for the Department of Legislative Reference. First, let me apologize for the tardiness of our bill report. It was just circulated today. In essence, our bill report says, I wish we had more time to discuss this very complicated topic. As drafted currently, the bill, and more so the amendments that are being put forward today, are vague, overly broad, and present certain internal conflicts within the charter. And if passed the way they are, will inevitably present certain lines of interpretation that will be confusing both to this body and then also will present future issues between the Law Department and the Inspector General in the future. I'm happy to discuss any of these issues in the future, but just to keep it short, given the number of people in the room today, I'll leave it at that.
Take a couple more minutes to go a little deeper, please. You got 4 more minutes on the clock.
Well, we're the small fish in the room today. I think the most important part of our report speaks to the language that's being proposed in the amendments today, which states that the insert certain principles in the executive, the mayor, comptroller, or city administrator shall, quote, promptly facilitate the transmission of records to the office of the Inspector General as an authorized individual as described in the Maryland Public Information Act. The language as it's written presents begs, the following questions. Which records shall be transmitted and why? Are we talking about all records? Is this a constant state of transmission, or is it upon request? In addition, the term of art which is used here, authorized individual, as defined in the Public Information Act, isn't actually defined. It's used as part of the definition for custodian. And in it, it has to deal with an individual who is physically holding custody of a government record or of a record. Here, the office is not an individual. I don't necessarily see this as a critical conflict. It can be fixed by amendment, but inherently, it doesn't make sense when it relies on the MPIA for the use of that term. In addition, currently in the charter, my department, in addition to drafting all laws and regulations for the city and for codifying those, we're also responsible for administering the records and the archives program on behalf of the city. Section 93 of Article 7 states, and I will not read this entire paragraph because it is long and it was written in a minute ago, effectively states that it's my department's responsibility to keep the records of the city, to ensure that the city's history is maintained, and to ensure that those records that we do keep on site here or at our archives facility on Matthews Street are made accessible to the public in the responsible manner as governed by separate retention schedules, which must be approved by the state archivist. If we pass a language as proposed today, there is no discussion, there's no savings clause, there's no relationship between the language being added to the charter or being proposed to be added to the charter and our responsibilities. Again, I don't believe this is a fatal flaw, but it needs to be talked out, and we need to add language to speak to the relationship. And actually, the bill in its original form does this, and I think it does it artfully when it states on page 2 of the first reader in lines 19 and 20, for the purposes of investigating fraud, financial waste, and abuse in the city government only, the Inspector General, finish the sentence. In this context, we understand why the Inspector General is reaching for certain records. The Inspector General is entitled to have their own rules and reasons why they're accessing them, and they have their own internal processes that we ultimately have to rely on them to execute in a dutiful way, because that's why they're there and we trust them. I think this bill needs more work. I understand that we are up against time pressure with respect to getting this passed, so it may be certified to the State Board of Elections and ultimately put before the voters of this city. But as drafted today, and as the amendments as drafted today, it does not work, and that's our position.
Thank you. You still have 11 seconds on the clock. And I'll use your 11 seconds to say it's not every day that DLR is asked to issue a report on a bill. It is every day that we're asking you to write lots and lots of other things for us. So I'm glad that you found the time at all, even to get this bill report to us at the very last minute here today. Thank you. Law Department.
Thank you, Chair Dorsey, Mr. President, and members of the committee. As explained more fully in Law's report, the Law Department cannot approve the resolution for form and legal sufficiency because it is fundamentally at odds with the State Public Information Act. We've also reviewed the proposed amendments, which are similar to the current resolution as written, in effectively requiring city agencies to give the Inspector General blanket access to their records. This is similarly contrary to the PIA and can't be approved. Yeah. Is it better? All right. In short, there's nothing about the current charter that is a barrier to such unrestricted access. It's state law itself. And the Supreme Court of Maryland, along with the Attorney General, are very clear that no charter amendment or any other local law can circumvent the PIA. The PIA applies explicitly to governmental units within a political subdivision, which means individual city agencies. Each agency is the custodian of its own records, and crucially, requests from one agency for the records of another agency are governed by the PIA, including the PIA's mandatory requirements for protecting certain kinds of information. So the PIA defines custodian in two ways. One is the official custodian, who is the agency official responsible for the care and keeping of public records. It's typically the agency head. It's the official custodian's responsibility to respond to PIA requests made to the agency and to make sure that records and information that are confidential under the PIA are protected from disclosure. The other definition of custodian is any authorized individual who has physical custody of records. Now, as Ben was saying, this is the only place in the PIA where this concept of authorization occurs. Typically, this concept of custodian includes agency employees who have agency records as part of their job duties, or in some cases, other entities that have permission to archive, manage, or store that agency's records. A good example here is archives. Another one would be the Baltimore City Information Technology, or BCIT. So BCIT is authorized to manage agency electronic data and systems on behalf of agencies. BCIT would not be the official custodian of other agency records, and it wouldn't be authorized to access and use those records for its own purposes, just like it wouldn't be authorized to unilaterally share records of one agency with another agency. This type of sharing would still be subject to the PIA and subject to the legal responsibilities of that agency's official custodian. So the Inspector General's role in city government is nothing like this. The OIG is responsible for investigating complaints of fraud, financial waste, and abuse in city government, and is by design housed outside the executive, legislative, and comptroller functions. Therefore, the Inspector General is not and cannot be the official custodian of records that belong to these other agencies. And the OIG is nothing like an archive or a centralized data management repository that would provide the legal basis for authorizing that office to have physical or electronic custody of other agency records, let alone to access and use those records for its own purpose. So crucially, providing the Inspector General with blanket, unrestricted access to the records of other city agencies, as envisioned in this resolution and in the proposed amendments, would amount to an illegal end run around the PIA, which requires that records shared between city agencies are reviewed for mandatory confidentiality protections. Maryland courts and the Attorney General have consistently concluded that an oversight entity's access to the records of another agency is subject to the PIA's mandatory exemptions, notwithstanding local law that purports to grant broader access. This was the case in Montgomery County versus Shropshire, where Maryland's highest court said that the PIA protected personnel records from disclosure to the County Inspector General, notwithstanding broad local law that required each county agency to give the local Inspector General any documents requested, and notwithstanding the Inspector General's statutory subpoena power under local law. In other words, it's state law that governs the Inspector General's access to the records of other city agencies, and the charter can't override that. Which brings us to the part of the resolution about constructive supervisory authority. This provision, too, would illegally circumvent the PIA's mandatory protection for personnel records of an individual, which requires custodian to keep such records confidential unless it's to the subject of the records or a, quote, elected or appointed official who supervises the work of the individual. In interpreting this provision, the Attorney General, in an official opinion, said that the word supervise is crucial, and that the Attorney General believed that some concrete nexus of real or potential supervision must exist between the official and the employee before the exception applies. The IG doesn't have supervisory authority outside of the OIG and does not play any role in personnel administration, therefore wouldn't be able to have supervisory authority in a way that would circumvent the PIA to get those records. Let's be clear, the Inspector General does play a very important oversight function regarding potential fraud and financial waste and abuse, and that office's access to records, both internal and external, is vital. You all probably remember I actually was in that office for a couple of years as the director of the ethics board. I know how important that work is. Although the OIG's access to internal city records is governed by the PIA, the mandatory PIA protections that are most often applicable for personal medical information, personal financial information, attorney-client communications, and attorney work product do not present substantive barriers to many, if any, OIG investigations. The IG can also interview folks at will. There appears to be a lot of misconception about the extent and amount of redactions that would be required by the PIA for records given to the OIG. They are minimal. There are no broad PIA protections for city financial or procurement records or for most kinds of internal communications. And the OIG has subpoena power to obtain third-party records that are relevant to an investigation, such as the third-party vendors or contractors who we heard about with the Sidestep program. Indeed, the law department has and will continue to assist the OIG as our client in enforcing those subpoenas when requested to do so. But the law department cannot approve this resolution, the proposed amendments, or anything else that would have the effect of granting the Inspector General unrestricted access to the records of other city agencies. That result would violate the PIA and overreach the state legislature's careful balancing of access to records with important protections for privacy and privilege. Thank you.
Thank you. Finance.
Good afternoon, ladies and gentlemen of the committee. Gabriel Stewart-Sykewitz for the Finance Department. We defer to the Law Department's position.
Thank you. Okay, that is all the agency.
See, we have the Ethics Department here.
We did not refer the bill to ethics.
She did, you have a report from them.
We have a report. I just want to, the bill did not actually refer to ethics. I'll give the Ethics Board an opportunity to speak.
Honorable Committee Chair.
Speak to the microphone, please. Thank you.
Honorable Committee Chair, Vice Chair, Mr. Council President, and committee members. The Ethics Board has broad investigative powers within the confines of Article 8. These powers are similar to or the functional equivalent of those of the IG, or vested in the IG. The board's loss of investigative abilities resulting from the law department's rescission of direct access to city records resembles that experienced by the IG, in addition to being forced to potentially glean information from blacked out, redacted records. The board is now also forced to pierce the statutory confidentiality.
Can you provide us your name, please?
Christoph Amberger, Ethics Director for the last 4 years.
Thank you.
The board is now also is forced to pierce the statutory confidentiality by disclosing the identity of the respondent and complaint-related facts to entities outside of the investigative team. More importantly, the rescission forecloses the board's ability to appeal the department's redactions. By assuming the role of agency custodian, the law department now acts as an adverse party that is conflicted out of representing the board in adversarial procedures, such as appealing the department's own redactions. This means that every citizen in Maryland has more rights than the agencies entrusted with oversight of city employees. If the voters and city council had intended this catch-22 in 2018, they might as well have farmed out oversight to our local media because they have an intact array of options to appeal. At the core of the current conflict are definitions of legal terms of art. For example, the department denies the OIG's functional status of custodian because the IG does not supervise any official and employee outside her own office, but it concedes that the IG has oversight responsibilities. Now, oversight and supervision are one and the same. The one is the English term, the other its Latin translation. I refer you to Black's Law Dictionary's definition of to supervise, to have general oversight over, to supervise, or to inspect, as in Inspector General. Conversely, the person in charge of oversight, the overseer, is a superintendent or supervisor, a public officer whose duties involve general superintendence of routine affairs. What better definition can there be for the office of the Inspector General and the Ethics Board? By virtue of their oversight responsibilities, the OIG and Ethics Boards are supervisors for the narrow purpose of lawful investigations and for purposes of the MPIA. The MPIA, as my colleague cited to before, defines custodian, among others, as any other authorized individual who has physical custody and control of a public record. Now, when we're looking at when the MPIA was passed, public records were stored in locked file cabinets with a bent key. Physical custody and control of electronic office records, however, consists of direct access. The same access that the IG has had for 8 years, the same access assigned by the administrative manual at AM 118-1 to BSIT, the Law Department, Human Resources, and the OIG. The OIG was thus in full compliance with the MPIA's definition of custodian. I would like to point out that any use of a city electronic device requires waiver of confidentiality by its user. Any conflict with the MPIA and any proximate liability arise from the rescission of that authorization by the Law Department. The department argues that this curative amendment constitutes an unlawful end run around the MPIA. It absolutely does not. By express authorization of the IG and by extension, the Ethics Board, it works within the parameters because it is not the state who authorizes, it is the municipality. The MPIA was never conceived as an internal bureaucratic shield for public officials' malfeasance. The Attorney General himself acknowledged in 2001, relying on a previous opinion dated 1975, and I quote, "It is implicit in the personnel records exemption that a city agency charged under a municipal ordinance with responsibilities related to personnel administration have access to those records necessary to carry out its duties." This amendment is a touchstone for the mayor and city council's actual commitment to transparency and accountability in government, and the board hopes that you recognize the importance that it is passed. Even if challenged later on, the ensuing litigation would resolve the questions of law via the appropriate process, the appellate court, and the Supreme Court if necessary, and create final clarity for this matter, because that's what they're there for. Thank you.
Thank you. We made a late request to have anybody from BCIT here. Are you, if we have questions related to BCIT, are you available, are you able to maybe respond to some of them?
Between myself and the law department, we should be able to answer some of them, and then anything that we don't have the information for, I'm happy to provide in writing from BCIT as expeditiously as possible.
Okay, great, thank you. Okay, we'll take time now for committee members to ask questions of the bill sponsor and anybody who has just given reports to us here. I will just ask one quick question myself first, and then I'll go to the vice chair, and then I'll go to Councilman Jones, and then I will go to Councilman Blanchard, and then I will go to Councilman Ramos. To the Inspector General, do you believe that you should have access to attorney-client privileged documents? Make sure you turn your mic.
The way we are one city. It was best described in that within one city, when we are oversight, I have to look at what the standards are within the Association of Inspector Generals. This office with the approval of our board, published a paper on privilege and how it affects the Office of the Inspector Generals. The Office of the Inspector Generals have the ability to review that as well.
I don't think that I'm clear about the answer you just gave. Do you believe that you should have access to attorney-client privilege specifically?
If we are looking into
Specifically, I have an attorney-client privilege relationship in the communications that I have between members of the law department staff, in communications that I make on a nearly daily basis. And that is vital to my ability to do the job that I was elected to do. Do you believe that you should have access to those privileged records?
If you're talking about emails you have between the law, we've always had that. We've had that for 20 years. We do data pulls, and then we segregate to what our investigation is looking for. So it's a misconception to believe that we are reviewing every email, because once we receive the emails, we focus on what the investigation is.
I'll ask
And
the
that may
question.
include
I'll ask the question again. Do you
communications
believe
you
that
have
you
with
should
your lawyer.
have
Yes,
access to
that
attorney-client
is-
privilege records?
That is what Inspector Generals have.
Okay, thank you. Councilman Bullock.
Thank you, our colleague, Councilman Conway. Thank you, Inspector General Cummings. Appreciate you being here. There's been a lot of discussion today around MPIA and MPIA compliance. My question is around how materials being accessed, or what type of materials being accessed. So let me ask it from this perspective. Has the OIG's office ever been able to or access information that has not been reviewed for compliance with MPIA?
So, as the Ethics Department stated, MPIA is not a new law. It was established, I believe, in the 70s, maybe 1970. The Shropshire case, again, not a new court case. It's been around 15 years. Until recently, MPIA has not been weaponized against our office. So, in the past, the office for decades has not been subject to MPIA disclosures. We have always had direct access to files, to correspondence. Now, with that, there are controls in place. Within our office, we have policies and procedures. But also, during that time, for example, with email correspondence, BSIC could review what was being pulled by our office in the systems. That was always a capability. However, since January 23rd, we've lost that access to monitor even our own files in our own server. So the Maryland Public Information Act has been around. It has not been weaponized against us until recently. Now, there was a legislative letter. It was not an Attorney General opinion, but that letter was provided on February 6th, which then we received a email from the Mayor's Chief of Staff, J.D. Merrill, which stated that the Mayor's office had a desire to develop protocol that preserves the OIG's ability to do its important work lawfully, and our intent to have the law department take lead on those discussions to dispel any concerns about the Mayor's office involvement in those discussions.
Okay.
The law department and the Mayor's office are non-investigative partners per the charter, per our responsibilities. But yes, the MPIA has not been, and we've never had an MPIA violation. However, we have found that in other agencies and have reported on that.
So that's helpful. Let me work it backward, given what you just mentioned. So essentially, you're mentioning that the MPIA, again, has been in effect since the 1970s. However, the OIG's office has not been acting in compliance with the MPIA, and now it's being asked to. Is that what you're saying?
I would actually, with all due respect, I would state that the law department are the ones that are applying the MPIA. So
You said they're applying it?
So I would say that the law department are the ones that are applying the Maryland Public Information Act. To say we are not in compliance would be to say that the prior city solicitors, the prior administrations were also not in compliance with MPIA.
Right, I get that.
Including
I
a
guess
former federal judge who was a prior city solicitor and other very, very distinguish city
No,
solicitors.
I get that. That's helpful. I guess I'm just trying to get to where we are, because I know the conversation today has really been around the MPIA, and again, compliance with MPIA. And you're saying that for years, and you, to use your term, you mentioned weaponized. I think folks might use a different term, but that essentially the OIG had not been subject to MPIA. So you're saying yes to that?
Correct.
And
I would say
now
yes.
they're being subject to MPIA, and that is now the issue. Follow up to that, and this is actually for the Inspector General. One thing I'm curious about too is now if we go down the route in terms of MPIA requests, I'm curious in terms of how long would that delay the information you get? So, because again, it's not saying that you can have access, but it's not immediate. So, how long does it take you to access information using the MPIA?
Well, like we said, when we started to do the sidestep program, that's when it really became into effect, because I asked for the material on October 22nd. It wasn't until January 16th that I received the information from the law department with 200 pages redacted. And to give you an idea, the information that I was requesting was financial data that nonprofits had presented to Monzi to prove that where the money went. Now, in addition to that, I also requested a lot of policies and procedures, and those documents, I was like this tall, those documents we got. But what we didn't get was what mattered, because my job is waste, fraud, and abuse. What I didn't get was the financial documents that showed where the money went. And that is the concern. And that took 3 months. So what I did next was I subpoenaed the record, because it's interesting, the Shropshire that everybody keeps mentioning, there are no subpoenas in Shropshire. So the judge said, if it hadn't been subpoenaed, could be different. So we turned around and we subpoenaed the documents. And they had till the 22nd. It was the 23rd that they took down my access.
So the policy documents, you got those, it was 3 months, you're saying it took?
3 months to get redacted documents that would not enable us to do our investigation. But because my team is very talented, the few documents what we did get that actually had information, we were able, through investigative techniques, to find tens of thousands of dollars of fraud. Now, I would imagine if I could have the other 200 pages, perhaps there could be fraud in there as well.
Okay, one follow-up question. This question is not for you, but more of a statement than a follow-up. So again, one of the things I want to be clear about as we talk about fraud, one of the things that's mentioned is that the city had been defrauded, right? That the city, that we're not saying that the city was engaging in fraud, but the city had been defrauded by some of the vendors they had been operating or working with.
Well, you don't know that. And you don't know that because you don't know if they were working together to take the money. See, those are the type of things that we have to do, and we have to interview. And when you're given documents that don't have human beings to interview, and you don't know who's involved, you don't know.
Okay,
and I've been doing this 20 years as a prosecutor and 16 years as an inspector general. So this is the type of thing that we do to help find where the taxpayer money goes.
No, I appreciate that.
So I can't tell you that because I don't know, because I have not seen the documents. They're blacked out.
No, thank you for saying that, at least in my last question. And again, one of the things I will say, appreciate your acumen and your diligence in doing your job. You've been excellent at doing that. It's not your question to answer, or maybe you can, but can anybody tell me what's the process in terms of going through appealing redactions and what that looks like? Because I'm not sure how that works. I understand that the information was redacted, but I know there's an appeal process. Can someone answer how that works? And that's my last question.
Can I want to get clarification on your last question. Madam Inspector General, you said that you received redacted documents in January, but that at some other point, it sounded like you did receive policy documents.
No, at the same time.
Same time,
That's why the
okay.
documents was such a big pile.
Okay, thank
Because
you. I
those
just
were
wanted to get
policies.
clarity. It sounded like you got them
To
at
clarify,
different
we did receive policy documents throughout the process during those 3 months. Now, the actual invoices and contractor supporting documents, the redacted and unredacted supporting documents, we did not receive until January 16th.
I got it, thank you.
Back to the appeal process.
Oh,
Yeah, sure.
you can go to court.
Yep.
We'll go to Jeff.
Yeah, Jeff Hochstetter from the Law Department again. The PIA has specific remedies,
Come closer.
has specific remedies, both administrative remedies and judicial remedies. The administrative remedies are sort of appealing or at least requesting mediation with the PIA ombudsman if you believe something has been redacted incorrectly. If the ombudsman can't successfully mediate, the ombudsman can issue sort of a determination, final determination says it's either resolved or not resolved. That can then be appealed to the PIA Compliance Board, who has authority to, review the matter, order that the redactions be, taken off and the records be disclosed, and then that decision can be appealed. There is a separate process for direct judicial review of a PIA decision, and the part of the PIA that governs that specifically applies to governmental units. So those remedies are available, and you do not have to exhaust the administrative remedy before you go straight to court for a PIA matter.
Thank you.
Councilman Jones?
Thank you, Mr. Chair. I'll start off with a statement and follow on to my question. So throughout the hearing, I've heard the term used, it's always been done this way. This is the way we always do it. Just as a new council person who's often trying to change policies and certain things, I hear that a lot sometimes in city government. And I will just caution on using that as a notion of that we're doing things the right way. Or that we have been doing things the right way just because it's always been done that way. So I just want to caution on using that notion because sometimes I think it holds the city back when you say, oh, we've always done it this way, so that's the way we'll continue to do it. But on to my question. If, I guess it goes to the OIG, I guess this question is directed to you in your office. If, things get passed, it goes to the court, it gets approved. Just wondering what protocols does the office have in place to protect sensitive information that you all may come in contact with?
The office has, and I'm sorry if it sounded like we were saying it's always been done that way. We follow, I'm a certified Inspector General, and we follow best practices, and we follow what's known as the Green Book, which is the standards throughout the United States of America for Inspector Generals. And I think that's very important. This was not in any way an arbitrary type of thing. And in fact, Baltimore County, when they were working on their Inspector General, they spent $100,000 on a blue ribbon commission. And that blue ribbon commission came up with, this is theirs, the right to obtain full and unrestricted access to all records, information, data reports, plans, perspectives, matters, contracts, memorandum correspondence, and other materials, including electronic data of county government. And just because you are new, but I want you to know that we worked very hard, and Ryan Dorsey, Councilman Dorsey, was integral in establishing this office. And Ryan Dorsey said that he actually wanted the more detailed way it was originally, with all of that in it. But the law department told us that no, she has subpoena powers. Let's just keep this simple for the future. Because she has subpoena powers, she'll be fine. And he was right. We should have left that in. But I just want you to know that this anticipation, I didn't expect it. Maybe he did. So your question, as far as I think it's important to know that we don't have the ability to pull. We have an IT administrator that has the ability to pull emails in the records, okay? And I think it's important to understand that for the longest time, it was two pillars, and each pillar had the exact same amount of access. Over here we had BSIT, and over here we had OIG, exact same access. And so BSIT could always see what OIG was doing, always. And we would pull whatever we needed, and they could always see it. But see, and this is what's important to the citizens, we could see if people got into our system. Because in my system are whistleblowers, are important investigations, are complaints I get perhaps about every one of you. I don't want that out. I don't want that weaponized. I don't want the Office of the Inspector General to be a weapon, which is why I neither confirm nor deny ever about what we have. But if they would have done this, I would have told you. That was my safeguard. But after January 23rd, that left. And now, I can't tell you. I can't tell you if people are looking at, many of you here may have given me information in the past. I can't tell you who's looking at that. I can't tell you. I can't tell you all the people that have come to my office and all the people that were brave enough to. And there's a lot. And there's also, I'm in charge of whistleblowers, okay? You set up the rules for whistleblowers. I can't protect them. You know, the sign out front says, your identity will be protected. And I can't do that, so I tell people now, I can't protect you. This is the Office of the Inspector General. So we have checks and balances. And I mentioned it before, and I'll mention it again. I think it's important that we have the different aspects of government. My job is oversight, but I don't know why we haven't been giving you as a legislative body the copies of the investigations as well. Because if it pertains to our city government, you have been elected. So why have you not gotten the important investigations that you needed? I think if you all would have read the entire DPW report, you know, we could have done things quicker. And if you would have read the entire fear of what happened with that Flint, Michigan, and if you would have read some of the things that I have had to keep very secret and private, I think things may have been different. So I think moving forward, what needs to happen is you all have actually saved my office more than anybody. The citizens and you all. Odette Ramos, she knew the situation I was in when my advisory board, you know. Councilman Dorsey, he knew it when he started this office. And I mean, they gave us the power. The people, 91% gave this office the ability to bring a report to you against any elected official. Think about that. I can bring you a report that is against any elected official. And now, how am I going to do that? Because I don't have the ability to, I mean, that's a law, and I don't have the ability to get the records I need to bring to you to tell you what was the truth.
And I guess in your answer, you
It's
touched
common.
on a lot of sensitive and important information that you
And I don't talk about
that you need to have access to. I guess my question is, upon getting access to it,
Oh,
what protocols
yes.
are in place to kind of make sure
I know. Thank you.
that this
Good question.
information
Good question.
stays,
Right.
you know, protected for the
the last 8
whistleblowers and
years, we
everyone?
have protected it with our lives. So what happens is my IT administrator, he has the ability, and he has, because he has the security and the ability to protect it into the IT world. And I'm probably really mangling this. Can you take over? Because that's not my specialty.
Sure. So sensitive and protected information, we take wholeheartedly seriously. We don't take it lightly that the fact that someone's name is a witness, subject, complainant associated with an OIG investigation could trigger retaliation, or just, you know, a notion that somehow something is going wrong. A lot of times we receive complaints and we're able to find out that they are unfounded and we close the case and no one ever hears about them. However, if the information of the complaint got out, it could damage somebody's reputation. So in our office, our agents adhere to very strict confidentiality standards. Knock on wood, we've never had any type of leak from our office regarding an investigation. When we receive information, we put it into a secure case management software that only our credentials can access, and where we can even have further ability to mark things as sensitive, to the point where only one agent and their supervisor can review that information. So even within our office, we keep things contained. We don't broadcast the information on sensitive cases to the group, entirely, as well as data, whether it be emails or any other type of data that might be maintained. It's our responsibility that I know our IT administrator takes seriously, as he's been with the city for over 14 years doing that job, to safeguard that information. So the only people that have access to those emails during that time frame would be the agents and their supervisors. We don't have time to sit around and read emails as a group together and conduct these, for lack of a better term, fishing expeditions. We want to be precise, efficient, based on our report output. We wouldn't have that output if we weren't. So we have to prioritize that, and we have to prioritize that information. A lot of times, witnesses who tell us information, we won't even meet them in City Hall. We will meet them somewhere off-site to protect their identity. There's also cases where sometimes the identity is so secretive that we will not even put it into our case management software. We will keep it in another secure location, because it is something that in Baltimore City, there has been retaliatory attacks, and we do have the whistleblower program to help protect against that. So as far as software we use to review the emails as well, we use a software that allows us to mark items such as attorney-client privilege, or items as, with containing PII, which is personal identifiable information. And we have never had any violation of MPIA in our reports where we've disclosed information, as it is a disclosure law. And I did mention our IT administrator. He has had, they have done data searches and data retrievals for the law department, even when they've designated him as the custodian of records for federal criminal cases, going back to even just as recently as 2021. He receives training. He also sits with agents and educates them on the standards that are expected of them. BSIT was also aware of his access, as he and the Inspector General provided privilege access agreements to BSIT on a yearly basis, which contained the list of the servers, and I'm not the most IT person myself, but the resources that he had access to, which allowed him to do that. To touch on direct access as well, it helps us keep things secure. If we have to go to a third party within the city to request information, those names are now known, which again, they could be subject to retaliation, and then the confidentiality of our investigations is no longer. So the access we have and the information we receive, we take the safeguarding as seriously as anything I can think of.
And just a follow-up question real quick. In your testimony, you mentioned he also receives training, referring to the IT person. And I've heard you have your IT person, you have the supervisor, and you also have agents. These are the people who might have access to that confidential information. Are any of those people trained in like MPIA or HIPAA or any other certified trainings? Are they certified in any of those?
Right.
aspects?
So through the Association of Inspector Generals and Certified Fraud Examiners, they are, most of our staff are certified fraud examiners, as well as
how about as far as like data protection? That's what I'm kind of worried about.
Right, that's encompassed within investigations training as well. And then when they are reviewing the information, like I said, whether it's emails or other content of information, They have the ability to market, and then we also have the ability to, and just recently, we have the ability now to make sure that, I'm sorry, I lost my train of thought there. But but also, like I said, we have never had a disclosure related to that, which I think speaks to the seriousness which we take those issues. We have found where other agencies have had those disclosures, which has been a part of our review process, which in the technology acceptable use policy of the city, agencies such as us are designated as review agencies. So that way we can help identify those measures when they occur.
And I think what I've learned too in places where leaks have come out, the more protocols and policies you have in place, the less likely that is to happen. And the more people are, officially trained in data protection, such as, HIPAA and so forth, the less likely those things are able to happen. That's why I asked those questions.
And I think as a whole on the city, I think every agency should have that. As we are the public's body, we are responsible for all the documents we receive. So I think it's something that on a more robust level, I would welcome at a full city level as well too.
Thank you for that answer. Thank you, Mr. Chair.
Councilman Blanchard.
Thank you, Mr. Chair. This is a 2 questions per round thing. Okay. Sure. So I think the questions so far have kind of hinged around best practices around sensitive information and a couple different things like that. My own sense is that we do, at least I, think that the Inspector General and Inspector Generals in general should not be subject to MPIA like other folks, and this makes a lot of sense to me. I think the most pivotal question to me is this state preemption question, because Lord knows there are a lot of things that I want to do that the state would like to see in the city of Baltimore that we are precluded from by state law. And I'm a little hazy on the timeline here, but I think the general gist of it is BCIT, or the mayor's office, access was pulled in late January. The Attorney General's office gave their, I guess what was later called advice, in early February. And then at some point shortly after that, Montgomery County had a similar, the county executive's office in Montgomery County pulled access to the Montgomery County Inspector General. And then a state delegate, well, there was a bill, one of the co-sponsors was state delegate from Montgomery County. The other one was state delegate from Baltimore County. House Bill 1260 later in February was introduced to basically make sure the county IGs and the city IG are not snared by this. I guess, long-winded way of saying, first off, what's happening in Montgomery County right now? Is the same debate going on in Montgomery County?
No, it's not. They are very supportive of their Inspector General, and they will be moving. The thing that she had redacted was a personnel matter. Since that time, they're working to try to help her also be able to do the job without, because that's the oldest Inspector General, not her personally, but that's the oldest office in the state of Maryland. And that office was formed differently than ours. Theirs is a legislative office. We were formed by the people. We were formed by a charter amendment. We were formed in our charter. So it's a little different in that way. And but they are actually being very supportive, and she has been moving forward.
So the Montgomery County Inspector General is not having to go through the MPIA request process currently that the Baltimore City OIG is?
They do not, for instance, she's able to pull emails, they don't go through the law department. You know, I called people in the Washington DC Inspector General's office. They do not go through the law department. Baltimore County, they do not go through the law department. We never went through the law department until that came on February 6th. And I do think it's important, it's very important to realize there has been no new law. There has been no Attorney General opinion. Okay, when you're in, the law in Maryland is, and a real Attorney General opinion, which takes 9 months to a year. That's what the Attorney General himself told me. That letter was not that. That was an answer to a question by a state senator concerning allegedly concerning a Baltimore County education type of IG question. So there has been nothing new that has happened, but what has happened is an interpretation of the law has caused all of this.
Okay.
Interpretation of a legislative letter has put us where we are now.
Okay.
Can I add to that as well? So
Hang on.
No, yeah.
Yeah, I would like to hear from the administration if they agree with that assessment.
Yeah, let's be very clear. In older Attorney General opinions and in court cases, including Shropshire versus Montgomery County, the issue was very clear that the PIA and its mandatory exemptions applied to requests between the local Inspector General in Montgomery County and another local agency. There were personnel records at issue there, and in fact, that was one of the impetuses for changing the PIA to exempt police disciplinary records from the definition of personnel records. But let's not be misled here. The case law is quite clear, and it is settled. The letter from the Assistant Attorney General in February 2026 just confirmed that was the case.
And Councilman, if I can just add a couple points here. I want to make a general point here to something way back in the beginning that Councilman Conway said that I want to just correct. The law department is not opposed to access to these documents. The law department's position has always been the importance of following the law here. Now, you brought up the other counties. I want to clarify a couple things. First of all, in Baltimore City, the law department does not need to be on every one of these requests, nor does the law department need to review all MPIA requests. Typically, if an MPIA request comes into an agency, the agency can choose whether or not that agencies produce records in response to MPIA requests all the time without going to the law department first. Agencies will come to the law department if they have a question about does this need to be redacted or not, because that is a legal question about how that is, where that falls under the MPIA. But that is not required. The law department does not need to be involved in every MPIA request or every OIG request. Another point of clarification on the other counties, and again, there's not an IG in every county in the state, but in the handful that do have them, the IG makes a request to the IT department that is then filled out. That is different from what had been happening here, which was the IT directly taking those documents, accessing those documents without going through first asking for those documents from the IT department. So an important distinction there that I just wanted to clarify.
So, and I do want to go to the bill sponsor after this, but so you're saying that the previous IT setup was in Baltimore City was distinct from the other 3 or 4 counties that have an IG?
Yes.
Okay, thank you. Mr. Bill Sponsor.
Sure, thank you. I wanted to just refer back to the AG letter that was provided, I think is evidence for why IG should not have this access. And this is actually covered publicly, and the AG himself actually quoted here says, it could have been written by a second-year law student, in that it was really just a summary of the MPIA Act in response to a legislator's question, nothing more. We are not opining on the Baltimore Inspector General's work or on Monty's work. we're just explaining to a member of the General Assembly, Senator Antonio Hayes, the contours of the Maryland Public Information Act. And so that letter was not actually intended for this issue. And I think there may be some overlap, but I don't know that it was really intended in that fashion. And I think we should be careful about covering it as well.
If I can, because that might be an appropriate additional line, but I want to, in that line of questioning about the comparisons between the additional counties.
Yeah. I just want to see them.
I don't want to get too sidetracked on the AG letter, because that's been brought up a number of times about it being written by a second-year law student. One thing it didn't say is that the opinion was wrong. And that is really what is at the heart of this whole legal question, is whether the MPIA applies or not. The law department has been very clear that we think that it does. We think that's supported by the case law. We think that's supported by that letter, the analysis, whatever you want to call it, from the AG. So obviously, others may have a different interpretation of that, but that's at the basis of the law department's bill report, and that's been at the basis of the law department's advice to the administration on this topic.
Did you have Councilwoman Ramos?
Thank you, Mr. Chair. I really appreciate this discussion. It helps to really try to understand what we're doing here. And obviously, the work of the IG has been extremely, extremely important for our city for so long, because we as officials need to be held to account. And so I'm grateful for all the time that she and her office have put in on this. I just have some questions to try to understand this better. For the law department, I have this feeling that it matters where her office is positioned in the charter, right? So right now, her office is positioned in the charter as a separate article, not under city council, not under the mayor, and not under executive departments, which I think my colleague who's the chair, I think did the charter amendment. And so I'm just trying to understand a little bit better if she was positioned in a different part of the charter, like under executive departments or something like that, would that make a difference in terms of access to records?
I think the biggest difference it makes that the IG is not placed in the executive, legislative, or comptroller functions is in effect to protect that office and its records. It is its own agency, and there would not be some way to, for the executive branch or the legislative branch or the comptroller to access those records that belong to the IG, again, outside of the PIA process. And let's be clear, the OIG's own records are as protected as any other agencies, and the law department continues to assist when there are PIA requests made for OIG records, for ethics board records, protect those on investigatory exemptions, all sorts of things, all sorts of other things. So to that extent, it's important to note that, yeah, that gives some level of insulation to the records of the OIG.
So I'm just trying to understand this a little bit better. So it helps on the OIG side for protection of of the office's own documents. Does it hinder access to other documents as a result of where she's positioned, or the office is positioned in the charter?
Again, as explained, only insofar as the IG is its own agency. Yes, the PIA would govern records requests between that agency and another agency.
Okay, thank you. I just was curious. I had heard something about that, and I wanted to just to understand that a little bit better. I think the work that my colleague has done, the work that I have done, and some others here, really value that particular piece around independence. Well, I just had a question about whether or not we went too far on the independent side where she wasn't able to get access to records as a result. So my second question is about, and I understand the sponsor has a response, but I want to just ask this real quick. The OIG has, the Office of the Inspector General has had access to records in this way since this transition to her separate article. And I'm curious as to during those discussions, I think Mr. Chair and some others were part of those discussions. Was record access discussed in this way? You referenced it a little bit, Madam IG, in terms of the difference between the subpoena power and the language that you mentioned earlier. And I was just curious, because once that got established, right, and then she was able to access records in this way, I guess I just wondered what, again, I wasn't in the council at the time, so I'm just trying to understand if she was allowed all of this access with the discussions that were had at the time, why we're restricting now? Is there a type of document like attorney-client privilege that is something separate? I'm just trying to understand what the challenge here is based on when we created the office to be independent in this part of the charter, what those discussions around records access was supposed to be. Because I would imagine that the MPIA came up during that time, and I'm trying to understand why things are different now. That's all.
So I personally can't speak to or explain the reasons that others in the past permitted certain kinds of access. Those details are part of the subject matter of ongoing litigation.
Yeah, I guess I need to look
well.
at the bill
So I
report
won't
from the
comment on that.
time.
I mean, I can say a couple of things. I mean, in my time at the law department, even in the last couple of years, I have assisted agencies in responding to requests from the OIG and have made minor necessary redactions before giving those records over to the IG. As far as timing, I mean, again, as far as I'm aware, once the extent of the IG's access was clear, revealing that that office had unrestricted access even to law department files, including attorney-client communications and attorney work product, the access was curtailed in order to comply with state law. I think as a general matter, past practice cannot be a stamp of approval on future conduct if it's revealed to not be in compliance moving forward.
Thank you. I wonder if I can have, and it could have been in some of the other, this is a separate subject, and it is maybe in the multitude of documents that we received, and I can't put my hand on it. Do we have a table or some document that could give us a little bit more about, you mentioned the Green Book, so I'm going to look into the Green Book, but what other jurisdictions are doing in terms of records access, in terms of not just our jurisdiction, our state, but other states, and not just access, but because there's like where they're positioned in the charter and what their PIA and all of that. I mean, I think it would be helpful, at least for me, to understand a little bit more about there's best practices and then there's like the standard practice. That's two different things. And I want to understand that a little bit better as we go into this, because I think it's, I want to make sure that documents that are supposed to be protected are protected, but that the OIG still has access to do what she needs to do. But at the same time, want to understand what other jurisdictions are doing so that we can either model a solution based on what we think is happening. There are plenty of times, which I'll admit I'm one of them, who says, well, we're unique and we should do it our way. I get that, but I'm really interested in understanding what those standards are and standard practice and best practices are, so that we can make a better decision based on that, as opposed to just trying to figure this out relative to the information we're given today.
Councilwoman, if
Can I answer that?
Whoever can get me that document, I would appreciate
Well,
it.
it's
And
it's
it would,
pub-
it would
Excuse
be
me.
for the committee.
I'm going to go to the bill sponsor because I also asked, I think similarly, if there was any other jurisdiction that has done what this bill proposes. But so I think that's an important information request. important point of reference for us. I'll go to the bill sponsor.
Sure. I will defer that question to the IG and the experts that know this and do this and coalesce with colleagues on this matter. Before I do that, I wanted to speak to your other question about structure of the IG, where it's placed, whether or not it's under the mayor and city council or otherwise. I think it's a really good question, and I think the issue at hand here is the interpretation that the law department has about MPIA, in that they said that we were out of compliance because they had this access that they believe they should not have had. But I think the interpretation is drafted in the bill report for both ethics and for the OIG, explains that they already had custodian access. And by the very nature of them already having custodian access, they meet the custodian needs, just like IT already has custodian access. And so even the arguments about supervisor and all those things are no longer relevant once they have access to that information. It was only once the law department took away that custodian access that it is now a question of whether or not we should give that access back to them. This whole bill, the intention of this bill is to just give them the access that they have always had that should never have been taken away. Is that clear?
Yeah,
And that is the best standards. That is throughout the United States, direct access, like I said before, is the standard of inspector generals. It's in the federal standard and it's in the state and local standard. I can tell you, like I said, Baltimore County spent $100,000, interviewed people from all over the United States, and the language they came up with is what I read to you. I also think it's important to note that my office, I am the custodian of the records of my office, like everybody is of their own department. Yet, when I asked to see the audit of who has been in my office, who has been in my records, I was told that is privileged.
Councilwoman Ramos?
Yeah, I just want to, if I can get the document, just piggybacking on your request in terms of if anybody's doing what we're done, but also like what are these, and I think it would be helpful for all of us to see it. So I understand. And
I'd like to ask that of the bill sponsor. Can you provide us that information? If anybody has done what is being proposed here in the state of Maryland. I want to be real clear too, because the Maryland Public Information Act is the Maryland Public Information Act, and this is what is at hand here as the source of debate. It doesn't matter what happens in Pennsylvania or Ohio or anywhere else. For comparison, does anybody else, has any other jurisdiction done what this bill is proposing, and what are the actual processes in place in other jurisdictions in Maryland that have IGs for them to be able to access records?
So
That's
Mr.
right.
Chair, to fully understand, I don't want to understand the question.
Yeah.
You want to understand if other IGs across the state have direct access in the way that we're suggesting here.
What exactly their processes are for getting that information. We heard from Stephen that other jurisdictions do not just have the right to go and essentially go into a file and say, I want this file, so I'm opening this file. They have a process of filling a formal request for information out from somebody. I don't know what all others do.
It's from IT. They go to IT.
Hold on, don't cut me off, please. And so that's what I'm looking for, a comparison.
I would just add,
in writing. I want something submitted in writing.
and I would just add if there's a way to summarize kind of where they're positioned in their in their constitutional document, charter, whatever it is. I think we're the only one with the charter. Everybody else has something, you know, because I think that is making a difference here, and I just want to understand that a little bit better. Does that make sense?
It makes sense. And Mr. Chair, with your indulgence, one piece to add to this, because this has come up before, in terms of this jurisdiction versus others, right? The fact that the OIG is an independent entity, right? And so part of the conversation has been around information sharing between agencies, right? And if you're going between agencies, then you need to have that MPIA. So that, I think that's also part of this question that's being asked too, in terms of where they're situated within government, and then to the context of the bill that you're proposing.
Sure. And I want to make sure the committee has got that for the record. We have that down, that request down. I think part of the reason we structured this as a requirement under the mayor's office is because that then satisfies that need. And so this is a requirement of the mayor going forward, and the people will then vote on it, and the mayor is supposed to help the IG meet that standard. So it is putting the responsibility on the mayor's office to provide that access, which the mayor's office has access over every agency's records if necessary. So, but yeah, I'm happy to do that.
I appreciate that. Thank you. I think that will help me a lot to understand this part. Thank you, Mr. Chair.
Thank you. I want to say that several people have brought up this idea of it was this way and the law department interceded and now things are not the way that they were. I'll just speak for myself. I have heard it said in a way that I interpret to mean that like there's something intrinsically wrong with the fact that the law department has interceded. I can tell you just in the last 2 years that I have, or the last several years, on 2 separate occasions, identified policies, practices of city agencies that I knew to be unconstitutional. It sounds like a big and scary word, but in these cases, it was very simple. The city had a long-standing policy, or rather the Department of Transportation had a long-standing policy with request to speed hump requests, that a speed hump could not be requested by an individual citizen of the city of Baltimore, that the Department of Transportation would not even consider the request unless it came from a community association, which meant that citizens of Baltimore were being deprived of their right to access a city service or to make a request for a city service unless they participated in a non-governmental organization where that violates the freedom of association by way of freedom of non-association. I shouldn't have to be a member of a voluntarily created non-government organization in order for me to be able to ask my government for services. And later on, I asked the same question about the Department of Public Works policy on saying that community dumpsters were only available 4 times a year or twice a year, whatever it was, but that they could only be requested by a community association. And this was even worse in a way because when asked for it, the Department of Public Works had no written policy actually explaining this. It was just well understood to basically every community association president that I knew. And I was again and again asked, why is my speed hump request being denied? Why can't I get a dumpster on my block? They get it over there. And the answer was always because this group of people that is a community association of some sort, they have been given this special privilege and power that denies you, and that's not right, and we need to change that. And it was only by going to the law department that I had to get the law department to step in and say, this is not okay. And neither of those practices is today what it was before I asked the law department to intercede. The law department stepped in and said, DOT, this is not legal. DPW, this is not legal. It just happens to be the case that governments do things imperfectly sometimes, and so I want it to be understood that there is nothing intrinsically wrong about the law department saying maybe something is happening here that shouldn't be happening. I think at hand here seems to be we have two conflicting points of view that are already being presented in a court of law. And I don't like the idea that I'm being asked to sort of adjudicate that where that's actually a judge's job. So it's hard to form questions at a certain point that aren't simply part of a process that would be me trying to adjudicate that. And so I guess I'm thinking aloud here, especially based on some of the notes that I've made while I've heard folks here. I heard that emails are city property. I also heard that when I accept the use of this device or the laptop that's in my bag, I sign a waiver of confidentiality. That waiver of confidentiality cannot supersede my right to attorney-client privilege. It cannot supersede my right to have my certain personnel information that is protected by higher law from anybody. And there seems to me that there has to be, and likely will be, the outcome of judicial proceedings that are already underway, that it will be determined that the law department's opinion is totally wrong, or it's not totally wrong, but they've kind of missed the mark. They've overstepped a little bit, and let's get it right, and here's what that balance should look like. Or they're totally right, and they've done nothing wrong, and that's going to be the, I imagine that that is going to be the case, the outcome of whatever legal case is happening. And so it either seems to me like the MPIA does govern here, and the court is going to tell us, seemingly yet again, because it seems like the courts have spoken kind of again and again and again how MPIA works, including between different elements of the same government, different units of the same government, and specifically in this Shropshire case pertaining to the relationship of the Inspector General of Montgomery County to the rest of the units of Montgomery County government. And so if it is the case that the MPIA does govern and set precedent here, then I'm inclined to say it seems like the law department's right. And if the judge says, no, that's wrong, then it seems like the kind of access that the Inspector General is hoping to have is what they're gonna have if the MPIA isn't governing in the way that it's being argued and exercised right now. So it's hard for me to discern what this can legally solve if anything other than what this court would already resolve. I don't know that I have any other particular questions at this time. I want to go back through the committee members because I want to see if they, again, have any other questions, and I'll go through the same order I did before. Mr. Hamburger.
I feel compelled to, with all respect, to correct your assumption, but it's before the court right now, before the circuit court in Baltimore City, is the matter of enforceability of the IG's subpoenas. The subpoenas may be treated as MPIA requests by the law departments, but they are a distinct entity that is completely removed from the issue that is before this honorable council today. So any decision that is made by the court in this matter has very little to do with the amendment to reestablish access to the documents that the Inspector General had before. I also would I would caution against applying especially Shropshire to a wider area of city government. Shropshire is so narrow that it actually now comes with a little flag in Westlaw that says superseded by statute. Shropshire is for the proposition that police IAD records, disciplinary records, equals personnel records, equals protectable under one particular provision of the MPIA report. It was not before the court that the second provision of that same article said there are, and I'm paraphrasing here, I don't have it before me, the records are disclosable, must be disclosed. There's actually a shall in there to an appropriate custodian, within the same government. It is inappropriate to extend that, and I know it has been done frequently, to roll that out into a general rule that says, Shropshire says all government record requests are, all government access to records has to be treated pursuant to the MPIA. I have argued Shropshire among many other cases regarding disclosure of records for the State's Attorney's Office, PIU, Police Integrity Unit, for 5 years, and I'm very familiar with the holdings in there. So another issue that I would bring up, if there is the application of the custodianship of records through the law department, that application has to be consistent. For example, my colleague in his bill report indicated that there should be no problem obtaining financial records because they're not personnel records. Well, all those 200 pages with blacked out information were financial records. There were the invoices by city vendors, third-party city vendors, submitted to the controller to be paid. Those are not protected by anything, and yet the OIG, did not receive the full request. In fact,
let me ask, is that not a matter at hand before the court, though? Are these the redaction, the redaction of these records are not?
So the redactions that were made as a consequence of the Inspector General requesting that information. After the request was denied, the Inspector General issued a subpoena for those same records. And it is that layer, that legal layer, the enforceability of the subpoena that is before the court right now. It is not the general application of the MPIA.
Can we just, because there's something just factual.
Yeah.
Yes.
For the record, we needed to correct the misrepresentation that the pages and pages of redactions that sort of we've seen out there in various places were from the law department, and we can provide the committee with sort of a timeline and how this actually worked. Most of those redactions were actually the documents already in the possession of the agency because they had been redacted by the vendors because those accounts weren't actually being asked to be reimbursed. So they had been redacted on their own before they were provided to the vendor. So we're happy to correct this, but these redactions were not by the law department.
Yeah, it's like a pretty fundamental thing because this picture keeps surfacing, and those were actually redacted by the original third party whom the Inspector General could submit a subpoena to that we would then help them enforce. So it's sort of used, it's been wielded in this way that's quite misleading. So I'm glad we had an opportunity to correct that today.
Thank you.
And one more thing that has been misrepresented as well, the administrative manual on mechanical use or electronic use specifically says it's in accordance with state law, which would mean that whatever confidentiality waivers would not be able to supersede the PIA. Thank you.
Thank you.
I want to address one more thing from your.
No, I want to go to the.
This is about the.
I'm sorry, I'm going to the vice chair.
This is about the bill.
No, I was gonna say thank you, Mr. Chair. I didn't have another question. I have some other questions and comments that I may add toward the end, but I know that there are members of the public that are here, and we're going to get to testimony at some point, so I'll defer to others.
Can I be brief, Mr. Chair?
Excuse me, hold on 1 minute. We are 2 hours in. We have a lot of people here signed up to testify. I need to make sure that my committee is satisfied, that they've had the opportunity to ask the questions, that they're satisfied with whatever answers they're going to get here and now today before we can go to public testimony. And then I will give the sponsor of the bill a final opportunity to speak before we go to public testimony.
Mr. Chair, briefly, to your earlier point, it feels like we're like judges in a case with a lot of learned lawyers arguing two sides of an argument, and this is not, like, I'm not a judge.
No lawyers up here. There's one.
And so it's...
He doesn't get a vote.
They all sound, both sides sound compelling, to be honest. My question is, and I know that the city can't, we don't have authority over state agencies. Could I make a committee request for the Attorney General of the state of Maryland to give an opinion on this?
The Attorney General is responsible to respond to requests of members of the state legislature, state agency heads, governor's office, and the heads of Maryland's jurisdictions. The mayor's office can make a request of the Attorney General. We cannot.
Okay, I would appreciate that opinion from the Attorney General. That's I guess, a question directed towards the mayor's office.
Thanks, Councilman. I'll follow up with you on that. Obviously, I can't provide that response directly and unilaterally, but I will confer with the mayor and ensure that we follow up with you regarding your request.
And what is the specific?
You did hear me say it would take 9 months to a year, correct?
Councilman Blanchard.
So I guess it's a committee request to the mayor's office to request an opinion from the Attorney General on the matter before us.
Of the bill?
Yeah, if the Baltimore City government is actually allowed to do this.
Okay.
I'll follow up with you regarding our ability to submit that request, but I don't believe it would be timely enough for consideration of the charter resolution.
Thank you. Councilman Jones?
Thank you for your consideration, Mr. Chair, but I'm fine, I'm good. I would love to hear from the public.
Councilman Ramos?
I just have one additional
Please.
question, if you don't mind. Thank you, Mr. Chair. For the law department, I'm wondering if the access that the OIG is asking for, which she's had, does this have implications for other entities asking for certain information, any other agencies? Does it expand the, who could be accessing records? I'm just wondering if, again, trying to think about the future, if there's any other implications in providing this information.
So outside of the OIG context, it's been relatively routine. For example, the Department of Audits asks for HR records. We will assist HR in making sure that only permissible records go back to audits, things like that. So it applies across the board. Obviously, investigatory agencies usually ask for a lot more, so that's why it comes up more in these contexts.
But you're not predicting that if we end up providing this access, that there would be additional agencies or additional parties that would be interested in this kind of information, or that would like the similar access?
I think it's difficult to speculate, but also not sure how it would actually be implemented in accordance with state law, because it could.
I don't have an example in my head. I'm
Yeah.
just wondering. So yeah. Okay. Thank you. Thank you, Mr. Chair.
Thank you. I'll note my one last thing that is very specific to the bill and amendment as we have it. First of all, appreciating the DLR report and the notes about the artfulness of page 2, lines 19 and 20 as giving precision to something that is otherwise vague. It seems to me that the notion in the bill, sorry, I have too many papers in front of me, where is it? In the amendment, that the Inspector General's board should select a designee to determine even what can be released to the public, has this sort of conceptual concern for me, where it assumes, first of all, that the Inspector General's office has access to potentially protected information that is unallowable to be released to the public, and that whomever the Inspector General's board, who are members of the public, who also do not have the right to access that kind of information, my attorney-client privilege, my personal information, my other personnel things that are protected by MPIA, they can't be released to the Inspector General's board any more than they can be released to a designee of their choosing, in order for that person to then make a determination as to whether or not my protected information is protected information. That can't happen. As you know, that's deeply disturbing and concerning, that the idea is that somebody could have that and make that determination if they're not clearly empowered under the law to get it in the first place. That is, I'm putting that on the record as a concern of mine about the bill. We're going to go to public testimony now. I want to thank all the agencies who've been here. We're going to go to the sponsor. Before we do that, I have 2 sheets of people signed up here to testify. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people signed up. I said at the beginning, if you want to speak, you sign up on the sheet. We just pulled in the second sheet. So we have all the sheets. We have everybody who's signed up. We will also take public testimony. We have a number of people online. We will do all the in-person testimony first. Then we will go to public testimony for those who have their hands raised, who will call on each in turn. To the bill sponsor, Councilman Conway, please keep it brief if you can.
I would have been briefer if I would have spoke earlier. I want to address a couple of things. You said something that Ms. Allenberger started to allude to, which I think was helpful in noting that the court case is not about what is before this council today, before this committee today. Those are 2 separate issues, related but separate issues. This bill is about giving the Inspector General direct access, the same direct access that the Inspector General has always had. And I don't want to lose sight of the point here. These are 2 separate issues. If, that court case ends in any which way,
we still have a responsibility as a council to make sure that true accountability, true transparency, and fraud, waste, and abuse can be sorted out in a way that makes sense. I think I think we were talking about this world in which we've always done it this way. I think we also are forgetting that this is the first time that the Inspector General has ever had to issue a subpoena for internal documents. The Inspector General has always had direct access and never had to subpoena internal documents because the Inspector General has always had it. That is in our AM manual. When I got my device, my city device, I signed it. When I came on as a city council, I signed it. When I worked in the mayor's office, I signed it. That has always been the case. I knew the moment I took this job that the Inspector General had access to my emails. I want to be clear too, ultimately, you are all considering the passage of this bill to come to the council, but ultimately to go to the people. The people will decide. The people will decide whether or not they want the IG to have the direct access to this information. It's not even really up to us. We are simply making sure that it makes sense as it's drafted on paper so that it can go to the people and the people can determine whether or not they want, the law department to redact documents for, people who are defrauding the city. I still can't wrap my head around that. Who are we protecting here? Right. I see you giving me the eye, Mr. Chair, so I'll wrap up here. I want to be clear. I think just in this situation, I do not, in the same way that maybe you have suspicions for whatever you have, I don't fully trust the law department to do what is in the best interest of the city of Baltimore here. I feel like they are protecting some other special interests here, because if we were doing so, we would open up the documentation to figure out who is taking money from the city. I mean, that is what is in the best interest of the city of Baltimore. That is what is in the best interest of our taxpayers. Why are we protecting that? And so I want to bring us back to just like the basics here. We are, as a council, trying to solve that problem. The Inspector General's office was a co-custodian or an authorized individual or whatever you'd like to call it by the definition in the book. They already were. The law department made an argument to have that taken away and the IT department took it away. So now we are having this argument about whether or not they fit this understanding. They already fit it. So we're having these back and forths that I don't think are really necessary. Either we believe that they should have had that access to begin with and they should continue to have it going forward, or we believe we should take it away. And that is what is before the council today. And so I appreciate you for getting this on the books soon, because I know it's urgent, but I just want to make sure we do the right thing here.
Thank you. We're at 10 minutes after 3 o'clock. We are going to begin public testimony, and you can go. Anybody else who is here from an agency that has other things to do, free to go. There's not going to be back and forth. There's going to be every person who wants to testify is going to get 2 minutes. We will hear everybody, and that will be that. We will begin with Madam Chair of the Inspector General Ord as our first person to give 2 minutes testimony, and then we will go on to everybody else.
Good evening. Thank you for this opportunity. My name is Gail Guilford, and I am the chair of the OIG Advisory Board. I'm going to have 2 hats on today. I'll start with my first hat. The board is in agreement that we need to update with the bill presented, and we do not want access to reports because that would break the confidentiality. We would like to designate a lawyer-type person on the staff of the OIG to review that. We do not want access Secondly, I'm speaking as a Ladinsky Award winner, a Baltimore City resident, and a retired city employee. For those of you who don't know me, I served as both the MIS director for Baltimore City Police Department, and I also created and was the first Chief of Information Security Officer for Baltimore City government. I worked here from 2008 to 2021. During my tenure, I worked closely with 3 different OIGs, providing assistance at any time they needed in the information technology world, understanding that it grew quite differently between 2008 and 2021. I worked on multiple cases, from misuse of funds to fraud. One of the ones that stuck out in my mind when I was young and stupid and didn't realize what people did was a person who's in jail for 6 months, and he was paid every week, and if it was an anonymous tip, and if there had not been access to the time records, no one would have known. During my tenure, the OIGs have always had unlimited access. After 2018, when the office was set to be independent by what the citizens voted for, it became even more important to have direct access. They need direct access to Baltimore City billing systems, time systems, emails, and outside access with vendors and other entities. And this gentleman is correct. They can subpoena outside vendors. In inclusion, I can only say the OIG must have access to records and staff to complete investigation. And as busy as they are, nobody's wasting their time trying to read Gail Guilford's email when she was CISO versus investigating someone who's in jail and getting paid every week for 6 months. Thank you for your time.
Thank you, Ms. Gifford. Okay, Mark Cannon. Mark Cannon.
Good afternoon, everybody.
And
Mark
just
Cannon,
as
retired.
each person comes up to the mic, just make sure you pull it to the appropriate height and stand maybe 4 inches away from it so you're speaking clearly into the microphone. Thank you.
Mark Cannon, retired VA employee and veteran. Council District 4 homeowner since '99. 6 children through Baltimore City School, 2 through the county. Been out here with We Are Us for 8 years, putting my life on the line so we can make this city better. This lady right here, she's the only lady that person I ever seen literally go to the DPW yard when they didn't have water and sit on the container before Ronald Silver died. That's why I'm down here, before he died. We all know, what's going on. We all know that if the voters know, we know why. My new friend here, Jay, 91 years old, took his time to come down here. And, and just like y'all hear things, we hear things too. And he said he believes it's the mayor. That's what, you said that, Jay? And he said he talked to state person and all that kind of stuff. But, and in full disclosure, I used to come down here all the time when the mayor was city council and all that to support him on things like water bills and audits and all that kind of stuff. I agree with him that the mayor's office should have limited power on the board, on the, what you call that, the board. When he was city council president, he wanted limited power for the mayor on the board and stuff like that. This lady sat down there, and Ronald Silver still died from water exhaustion. We smart, just like the boys' school closing up. We know better than all this type of stuff, man. When the #1 killer of our boys in Baltimore City is murder by their peers, we've lost 2,000 or more Baltimore City young men look like me
Mr.
to
Chairman,
murder. And I
need you to
just
wrap
want
it
to, I
up
just
here.
want to read this, and then I'm done. I text one of my We Are Us leaders not long ago, and this is what he said. They had a big fight with family members and children, and we are trying to avoid people getting hurt. They had dogs and guns and knives. We up here with 30 brothers and community leaders. The school should have let us in years ago. We want to do this with all the schools that's having trouble. It should not be this hard in Baltimore City
Thank you, Mr. Cannon.
to look out for the citizens.
Thank you. Christina Flowers.
Good afternoon, all. Always a pleasure to come and speak before my great council of Baltimore City.
Afternoon, Ms.
And
Flowers.
always
You
to
have 2 minutes.
represent our most vulnerable homeless adults. Because when I think of fraud, waste, abuse, I think of the unlimited, uncalled deaths on these encampments. So that's something that makes me understand that oversight is a failure in Baltimore City. Oversight of these agencies that's operating underhandedly, underminedly. So I stand to thank Sister Isabel for some of her due diligence of work, because even I had to reach out to say enough is enough when it comes to the individuals that suffer behind the acts of fraud, abuse, and neglect. So you guys need to not underestimate the power of this woman, because it's necessary for us as citizens to remember each and every one of y'all face. Because I don't see myself wanting to vote for anybody that don't want to be accountable for the dollars. The money matters. And people in these streets that's dying right now, it matters when y'all let it go to waste. And these organizations is being investigated for mismanagement, misappropriation, probably millions of dollars in the homeless community where people don't have to sleep on these woods. If y'all would pay attention and stop some of these friendship quotes from happening. And I do believe this could be the mayor too, because once you start investigating people, everything gets shut down. So I thank you, Miss Isabel, for handling situations and cases that y'all have on my people's behalf, the homeless community, because they suffering a lot at the hands of our council people who don't want to pay attention sometimes. Like, the truth is the truth. The mismanagement, the misappropriation, it'll get worse if y'all would allow this to happen. This is unethical and inhumane. So there's no way in this world that council people can stand here and think this is okay.
Thank
y'all
you,
have a
Lord.
great day. I speak to y'all in love. Thank you, Jermaine, one of my council people. Thank all of y'all.
Thank you, Ms. Flowers. Peter Richkes. I just also look for, I know everybody's enthusiastic about this. Everybody's here. I don't want people's 2 minutes to be cut into because they have to stop for applause. And I don't want people to have to shout into the microphone in order to continue to be able to be heard while people are applauding. So we would ask that you please not applaud and just allow people the opportunity to give their 2 minutes of testimony, please. Thank you. Ms. Richkes.
Thank you, Chairman, members of the committee. My name is Peter Richkes. I have spent much of my career in public procurement and government accountability. I served as Secretary of the Maryland Department of General Services and as a Commissioner for the Port of Baltimore, and as a member of the Baltimore County Blue Ribbon Commission on Procurement Reform. Independent oversight matters. It protects taxpayer dollars, and it gives the public confidence that government is being held accountable. The city's Office of Inspector General has uncovered millions in fraud, waste, and abuse. That work depends on access to records. For decades, the city's Inspector General has had that access. Now that practice has been restricted by the administration, ignoring the city charter. That OAG advice letter cited in defense of these restrictions, as you've heard, Attorney General Brown has since stated that letter was only a summary of MPIA law that could have been written by a second-year law student and is not a formal opinion. In Baltimore County, we too have seen political efforts to weaken the Inspector General. Based on the recommendations of an independent commission, an intentional structure was created and then strengthened by public referendum to protect and enhance Inspector General independence. It's best practice, not precedent, and the AIG Green Book that an office of law not control or filter OIG access. A city or county attorney serves at the pleasure of the elected executive and is part of the executive branch. The Inspector General must be independent of that branch. The proposed legislation does not expand IG authority. It restores clarity and honors the wishes of the voters. An Inspector General cannot follow the facts if someone else controls the file cabinet. Thank you.
Ms. Richards. Mary Taylor.
Good afternoon, Chairman Dorsey and members of the committee. My name is Mary Taylor and I live in Baltimore County. This is my first time in this Baltimore City Hall and Historic Council chamber, and I appreciate the opportunity for being here today. I also serve as Vice President of the Baltimore County Parent and Student Coalition, where one of our main missions is holding Baltimore County Public Schools accountable for our children's education and more than 50% of local taxpayers' dollars, how they are spent. First, I'd like to thank Councilman Conway for bringing this important bill forward. I also want to acknowledge Councilman Blanchard's and the conversations surrounding oversight and accountability across our region, including our support. Many of us supported SB 15, the Baltimore County Inspector General Authority over Baltimore County Public Schools, which was brought forward by Senator Carl Jackson. These issues are not isolated to one jurisdiction. Public trust depends on strong and independent oversight everywhere. I am here today in support of Bill 26-0164, Charter Amendment, Inspector General, Custodian of Records. Through my education and community advocacy, I've seen firsthand how difficult it is for residents and parents to get clear answers from government agencies and public institutions. That is why the Office of Inspector General is so important. An Inspector General cannot effectively do their job without full, direct, timely, and unrestricted access to the records, and that access is critical and crucial for independent investigations involving waste, fraud, and abuse, misconduct, and misuse of taxpayers' dollars. Delays, barriers, and unrestricted access only undermine accountability and weaken public trust. As Councilman Conway said, who are we protecting here? In my advocacy work, I have filed many MPI requests over the years and receiving heavily redacted documents as unfortunately some of us in the public have to deal with. But the Office of Inspector General is different. The Inspector General cannot properly and diligently do their work if they are operating with incomplete information or restricted access. So when transparency is denied, controlled by the agency's question, the public loses trust.
Thank you, Ms. Taylor.
Thank you. I'd like to thank Inspector Cummings for her steadfast commitment and bravery, and I respectfully urge this committee to support Bill 26-014-64. Thank you for the opportunity.
April Kidmore, and did I get this right?
Parallel to City Hall is a building named after Councilman Harry S. Cummings, a Republican and the first African-American elected to Baltimore City Council in 1890. He enacted legislation that benefited the lives he represented. I'm in support of Inspector General Isabel Cummings because she also works to benefit the lives of the people in Baltimore City, which is 59% of Black population. I'm in agreement of the IG being the custodian, having full access to all records and files, as well as independent from the Baltimore City government with separate computer servers and computers to have oversight of the spending of taxpayers' dollars. It is unfortunate we are here today because of the loose spending of taxpayer dollars that only benefit those connected with someone in City Hall or an illegal immigrant. Black and white Americans know how to read, we know how to count, to be in financial industries, we have customer service skills with no language barrier, and we can go to trade school and we have ideas to open businesses. Instead, Black, white, and veteran Americans are dealing with mental illnesses, various substance abuses from drugs shipped in from other countries, homelessness, lack of employment or business opportunity incentives, and the government agencies that are supposed to provide assistance have no funding, and yet $700 is spent on 2 crab dips. The illegal immigrants receive thousands of dollars in emergency cash assistance, thousands of dollars in emergency food stamps, emergency free luxury hotel stays, emergency housing vouchers, immediate employment, and immediate business opportunities. Therefore, I'm making my way to Congress and meet with President Trump to remove the gold fringes from all flags and military uniforms, because that means the Constitution is suspended and protects the privileges of the writ of habeas corpus, which dates back to British common law in 1215, and it's a great charter known as the Magna Carta. And the suspension means American citizens has lost the liberties guaranteed by the Constitution. Basically, a king could keep a person incarcerated indefinitely without going through the court process. There are some people in political parties that are aggressive in illegal immigrants going through court processes because if a judge isn't satisfied of what they are incarcerated, the illegal immigrant, custodian, or lawyer can help them obtain freedom or even worse, citizenship. I'm almost done. America was built by strong men, not the alphabet people or those that mutilate themselves to become the other gender, because there's only two genders. Therefore, the gold fringes on
Thank
all
you, Ms.
American-
Kidmore. I think we've heard enough.
This is why
Thank you.
passed in the charter, so vote blue if you want to get screwed.
Al Freihofer.
Good afternoon. Thank you all for your service. 25-year citizen here in Baltimore, retired teacher. Heard a great deal about fraud and the purpose of the IG, the vital service they provide and must provide, as well as the issue of private information being private. My distress here is in getting a sense that the tilt of the conversation has been very much around issues of privacy, while there's a general recognition that we have issues of fraud to deal with. And my concern is that I have yet to hear much in the way of any testimony or allegation that the IG has in any way been loose or relaxed in their treatment of the data that they reserve. I just wish that we'd spend more time on the fraud issue, on accountability and transparency as you're describing it. And if we have to come back to the Inspector General later on for their malfeasance around treatment of information, let's do that. But right now, let's give them the tools they need to do their job. Thank you very much.
Thank you. Jasmine Riggins.
Good afternoon, committee. My name is Jasmine Riggins. I'm a member of the Police Accountability Board and former member of the Administrative Charging Committee, which is an independent body that reviews police misconduct investigations and determines whether officers should be charged. I also previously served as the Civilian Review Board Civilian Review Board Supervisor. I want to be clear, I'm speaking today as a citizen, not as a member of the PAB or ACC. I'm here to support the proposed charter amendment to make the Inspector General custodian of documents, but this hearing is more than about the Inspector General. It's about whether oversight in Baltimore City will function as intended or whether it will continue to be limited in ways the public cannot see. Oversight only works if it has three things: access to information, independence, and the ability to speak freely. When those are constrained, oversight weakens. When they are blocked, oversight stops. We are seeing that pressure today with the Inspector General, and we have seen it before. Under state law, the Civilian Review Board had clear authority to receive investigative files and issue subpoenas. When the board refused to accept restrictive conditions, the law department advised the police department to stop sending those files. The board issued subpoenas to compel production. The law department declined to enforce them. So the board acted. It retained independent counsel and went to court against the law department's will. Only then did the law department reverse course and advise the police department to provide the files. After that, the board dropped its lawsuit. That sequence matters. The law gave the board authority, but it had to fight to use it. We are now seeing a similar dynamic play out with the Inspector General. The city charter gives the Inspector General authority to issue subpoenas for documents needed to conduct investigations, yet that authority is now being narrowed through interpretation when involving city agencies. The law department plays a central role here. It interprets the law for the city, advises agencies on how to respond, and decides whether or not or how to act when subpoenas are issued. When that interpretation limits the reach of oversight powers, it directly affects whether those powers can be used. And this issue is not isolated. I just want to say that last year, the law department advised the Administrative Charging Committee, who has subpoena power, that it cannot issue subpoenas to the police department if it needs information that the police department is withholding. What I'm here to say is that the tools that were used against the civilian review boards in 2018, because they were allowed to sit there, are now being deployed against the Inspector General. This is a complete oversight system. If the Inspector General is weakened, civilian oversight of policing will be weakened. And I urge the committee to think about enshrining police accountability in the city charter, the independence, as well as creating an independent police accountability and oversight office that can access information and not be reliant on the goodwill of administration to administration. Thank you.
Thank you. Stancil McNair.
How y'all doing? Well, my name is Stancil McNair, and I just want to say, as usual, when I come here, I have something written down. But it's always like a show on here. It's never no honesty, and it's mainly come for a lot of y'all up there. Because I don't believe this lady should be sitting here because people forgot for over 30-something years, Baltimore City workers was hurting. She was the first person to reach out to us and engage. Everybody followed her blueprint. So everything you seeing being fixed in DPW, that's because of her. Not because nobody's sitting up here. And a lot of y'all done emailed, I done wrote. I even know some of the stuff y'all do backhanded, and I'm gonna be honest about it. And I don't think it's right. Some of y'all should be sitting on the side and being interviewed like this. And that's from the heart. Like, it's a lot of things been going on that is just not fair to the citizens. And I'm gonna be honest with y'all, I'm the president of Local 44 now. Last time I was in here, I was just a regular employee. And I told people a long time ago, election time comes around. And I'm gonna make sure personally that some of y'all don't get in here because this is unfair to us. And I know for a fact, 2,300 DPW workers, and we support her fully. We got her back fully. I'm talking about fully. So anybody come against her, they gotta come against us. So just be ready for this fight, because we in this fight with her.
Devonna Cosby.
My name is Devonna Cosby. I'm just a citizen here in Baltimore. I've raised 15 Woodlawn boys. They're all prominent citizens now. Baltimore City, they're your linesmen, they're your BG and the officials and all. But what I'm not gonna do, and this is directed to Baltimore City, is allow them to run an app game on me that they net millions of dollars a week with. No one in Baltimore City will talk to me. Every African American, you ask them, well, can you give me the name of the oogly googly? Because it's called Move It on MTA, okay? I'm gonna need my money from you guys because the youth are going crazy. The youth are going crazy. That's what I'm gonna put my money to. Brandon, you have a hustler in the White House, not a businessman. Because if we don't have downtown, because I was raised by Mayor Schaefer, Sheila Dixon, and Thomas Saunders is my biological uncle. If you don't have downtown running, up and running, Baltimore don't have no money. You need to get a businessman in there. Let's get some money pouring into Baltimore City so that everybody can be happy again. We don't have no harbor. We don't even have a movie theater, like they say. And it took me to get out here arguing downtown for them to even start thinking about downtown. I've never seen downtown so nasty and dirty, and we don't have nobody to come see us. We don't have nobody. Nobody. You know, if you went to New York, if you came to Maryland, you came into Baltimore City. We don't have that no more. The youth are running crazy. They don't have nothing to do. So what can you expect? You got to give them youth something to do according to their culture and then, you know, their upcoming, and then what's happening today. You need to put them back to work at 14, if I say so myself. But with that, all I can say is that I need help, and I need you to look into that, because they're getting millions of dollars probably. They say I don't use a computer, but they say I'm a second paycheck.
Thank you, Ms. Cosby.
This app shouldn't run in Baltimore City, and I should be able to talk to the mayor or something. I've contacted him so many times.
Thank you, Ms. Cosby.
The commissioner say his shirt come from the from the thrift store. I need help. I need security. I can't go back home again for the second time.
Thank you, Ms. Cosby. Terrence Dixon.
Peace.
afternoon, everybody. My name is Terrence Dixon. Thank you for bringing this board together today. Thank everyone that I know here. All right, I'm here, the owner, just to introduce myself, owner of Terra Cafe, the Boost program, all right, for youth in the city through BCYF. Was on the Mayor's Transition Committee the first time around. And I'm here because I love Baltimore, all right? I look at that so much stuff has gone on in these last years. Businesses closed, condition of our community, and accusations all over the place. There's accountability to be held. If we're to be held accountable, so should the mayor's office, and so should she have access to those records. If the same energy was carried that is fighting to keeping access to these records was used for our schools, for our businesses, guess what? We'd be a lot better than we are. As I come up Calvert Street and I see $2,000 screens, but I see people laying on the ground on manhole covers, it doesn't fit right. As I go through neighborhoods that had 12 businesses, small micro businesses, during COVID, the worst of times, and now we're in the best of times, and those businesses are gone. As I see my city graffitied and destroyed, as I see myself being on a corner 28 years and wondering whether or not I will make it to 29, it's a challenge, okay? These records need to be revealed. You need to be shared. If there's nothing to fear, why are we fighting so hard? I think that by these records being revealed, it will tell a story that people don't want told, okay? All right, we're into a new age. We are not back in the 1800s. This is 2100, all right? It is time for not black, it is not time for white, it is not time for plaid, it is time for human. And as we march on today, it is time to reveal. It is time to be held accountable for every part of the city, and especially those that pay taxes and your money, okay? You held me accountable. I think that everybody should be held accountable.
Thank you.
And it's no reason for us not to reveal, and it's no reason for the city council not to do what we've elected y'all to do. And that's to make sure that you keep us covered. You're supposed to be that barrier. You're supposed to be that level of justice. And I ask you to release these records, and let's let the story be told as the story was written.
Thank you,
Thank
sir.
you so much. My name is Terrence Dixon.
Ron Furman. Ron Furman.
How are you?
I'm well enough, thank.
I've been in the city 40 years, Max's Tap House. We're celebrating 40 years. Little plug there. I want to thank you for all you're doing, but I got to tell you, I'd expect this out of a DC circus, not Baltimore City. You've heard from everybody in this room. I don't think I can add anything else. Everybody I've heard is for this amendment. It needs to happen. There needs to be transparency. These are the people that elected you all up there to represent them, and they have spoken. We want transparency. We want the Office of the Inspector General to be able to review these documents, and the only way they can do it is unencumbered. It's kind of funny that all of a sudden the problems happened in the past couple of years. Seems like maybe somebody's got something to hide. You know, the last thing I'll say, I'm gonna make this really quick. The last thing I'll say is, if somebody in government has private or personal things on their city computer, they're cheap. Buy your own.
Thank you. Last in person, we have Keith Holt.
Hello. Hopefully my comment.
Could you please speak, just pull that mic straight in front of you.
Like, oh, right
Yeah,
here?
right where it was, yeah.
Got you. Okay. Hopefully my comments are well received in this space, and I say it with all due respect. And I want to be transparent before I say another word. I'm not representing any organization. I'm just a black man born and raised in the city who loves Baltimore. This hearing has talked about the Sidestep program, a program that no longer exists. It's ended, it's gone. Yet the council is spending city time, staff resources, and public energy bringing it back, while people are still struggling in the streets outside this very building. Let me give you some numbers that deserve attention. In 2025, Baltimore City recorded 568 overdose deaths, 425 of them involving fentanyl. Black men over the age of 55 are dying from overdose, 3 times the rate of their white counterparts. This is that I know, because I watched my mom bury both her younger brothers. Right now, 35% of Baltimore residents say they struggle to afford care. Actually, 7 out of 10 residents are worried about affording health care in the next 12 months. We have homelessness, unemployment, lack of rec centers, discrimination on our gay and trans communities who can't find jobs and have to resort to prostitution and other means to survive. These are the things that's actually keeping us up at night. What I am seeing in a constant pattern of targeting black leadership. Some contests, the skybox and amenities of Camden Yards has been used by every Baltimore mayor since Camden Yards opened in 1992. Every mayor has had a vehicle. These are not controversies. To be transparent, they only became controversies when the person in the office happened to be a young black man from Baltimore, for example, our mayor. I am not here to tell you that accountability does not matter, because it does. However, as leaders, I caution you to not confuse accountability with oppression or oversight with targeting. Accountability and oversight must be applied with consistency and with fairness. While this room debates old programs and crab cakes, Baltimore just reported 133 homicides in 2025, the lowest number in 50 years, down from 31% the year before. Non-fatal shootings dropped from 413 to 311. This is real progress that deserves support, that is getting the job done. I am asking our council and everyone to please keep our ears to the streets. Our city needs bold action on health equality, substance use, crime, economic development, equality, and supporting nonprofits that are actually boots on the ground going thankless work. This is what we sent you here to do. Thank you.
Thank you, Mr. Holt. We have several people signed up online or with their hands raised online to give testimony. We will start with Deb O'Neill. You've been...
Thank you. I'm here. I just managed to get myself unmuted. Thank you for the opportunity to testify on this important bill, which I strongly support. I have 35 years of significant federal experience working in management, budget, contracting, and HR. As you're well aware, these are all areas that are rife for the possibility of fraud, waste, and abuse. And I have seen those 3 things uncovered repeatedly throughout my career by effective IG activity. But I also know that that can only happen with access to, with full and open access to redacted documents. I do want to say that I'm disturbed by the testimony that seems to think that the people we need to be afraid will abuse that access are the Inspector General's office. There are laws, I'm sure, that govern how they are allowed to use that information, and if they abuse that access, I'm sure that they can be held legally accountable for doing that. But what I find really interesting is, of all the people in government right now, I think they are the people that the voters of Baltimore trust the most to handle that information correctly. We in Baltimore know that we have a well-deserved national reputation for corruption in office. Not giving the IG access, as we tell, as we are doing right now, simply perpetuates that perception that we are hiding things here. Sunlight, as everybody knows, is the best disinfectant. Let the Inspector General shine as bright a light as possible by passing this law. Thank you.
Thank you. Sharonda Huffman.
Okay, great. Thank you so much. Can you hear me?
Yes, we can. Hi, Sharonda.
Okay. Hi, I'm so happy to speaking with you today. I could not be there in person, but I do want to personally thank Isabel Cumming for everything that she has done for me through my about 6 years working with the city. And I think that one of the things that we're failing to realize is that only thing that's changing is the people who are being looked at. I was one of the people who was on a special committee offline after hours with Odette Ramos, trying to make an advisory board that was independent. And we were trying to think of all the different ways that we could have our independence, because I remember when we had the city solicitor, O'Shea, he used to chastise her for being right. And as a woman, I was offended. And I'm still offended that we're sitting here in this day and age, through everything that we've seen when I worked in city government, that we're having this conversation. Let's not give her the records. And you know what? I have been inspired by her and all the shenanigans that have happened in Baltimore City that I'm running in the county, which is a whole bunch of shenanigans. And I probably wouldn't be running until she brought to my attention what was going on with that inspector general. So I urge you to pass the bill. In fact, when the Banner had made an article about it, I'm the one that stated, well, if the people don't, or maybe it was the borough, if the people don't want to do it in the state, that I was trusting that this council would give her the records they need. And I think we need to do better than worry about if Brandon Scott's going to come get you next time you run for office, because that's what it sounds like. And what I've always been told is if you have to change yourself to be in office, then maybe you shouldn't be in office. Thank you very much.
Thank you. CJW, could you please also give us your name when you begin? Thank you.
Hi, sorry. This is Carson Ward of the Reservoir Hill Association. And for a body of officials who value democratic principles, let me remind you that the OIG access is a necessity for the survival of democracy. When city officials withhold, redact, or impede access to records, we are not protecting confidentiality. They are actively obstructing the visibility required to maintain a functional government. While this city struggles with an $85 million deficit, we have seen the mismanagement of ARPA funds that could have secured clean air and basic services, better water for our families and children. The OIG accountability is the only way to ensure that the public funds serve the public and not the privileged. The OIG needs access now more than ever. People are struggling financially, barely able to afford groceries and electric bills, so any waste is an injustice to the people. The Attorney General in that Ebony Thompson's arguments are at the level of a second-year law student. I urge you to pass this. In a democracy, transparency is not a threat to those who have nothing to hide. So if you do not pass this, you are signaling that you do have something to hide. And my last thing to the council, loyalty to friends does not provide a legal shield against the severe consequences of obstructing an investigation. Thank you.
Thank you. Tanya B. Again, please give us your full name.
Yeah, can you hear me?
Yes.
Yeah, yes, this is Tanya Banya. Good afternoon, Mr. Chair, council members. We are not your subjects. We're really more like your employers, and you're supposed to be good stewards of our resources. Right now, our mayor is not being a good steward of our resources, and if you sit idly by and allow him to continue to obstruct the IG's access to these records, you are complicit. I noted that Mr. Holt commented about the need for resources and important issues that have to be addressed across this city. Every dollar that is wasted, every dollar that is lost to fraud, waste, and abuse is a dollar that we could be spending to address the needs that are not getting met across our city. I urge you to not sit back and allow this mayor to continue to disregard the will of the people like he did with the BGE conduit deal, like he's doing now by attempting to neuter the IG. And I would caution you, as others have already, to understand that you will be voted out. We are tired of being disregarded by our elected representatives, and any one of you can be replaced. So I urge you to think about that. And Mr. Chair, you specifically need to learn how to speak to your constituents.
Thank you for your testimony. Jason Rodriguez.
Good afternoon, Committee Chair. Can you hear me?
Yes.
Good afternoon, Committee Chair and the committee members. Thank you for the opportunity to submit my testimony. I'll be really brief. I know that's surprising to this committee, but I support this bill and support the IG having the custodial powers. And so I ask that this bill be pushed in favor. I also want to publicly denounce this horrible accusation of the IG being racist. I'm not saying this as a Bolicuan or as an Afro-Latino myself, but I can tell you that all of my respondents or correspondence with the IG's office has been cordial, respectful, has never been in any way, to me, concerning. She's been open and transparent, unlike many of the city council members, including even our mayor's office, when I call for information and support, even calling into constituent services, many times I get no answers and no return calls. This woman is responsive. She will call you back, and she will hold a conversation with you in reference to the city's business. And I appreciate her for being open. So I'm asking that, again, that the council moves this in favor. The city has voted, or the citizens of Baltimore City voted 82% for this independent IG. Then the citizens came back and voted 87% for a citizen review board for the IG. I'm asking that you stand with the people and ensuring that the IG can do her work on the behalf of the citizens of Baltimore City. And again, I think that there may be something here, but again, what does the mayor have to hide? And what is the mayor afraid of? And why does it seem like the legal department is pushing back?
Thank you, Mr. Rodriguez.
Thank you. Yep, thank you. Thank you, Council President. Thank you, Council Chair, for the opportunity.
You're welcome. I want to thank everybody for being here today, for giving their testimony, for their interest in this matter. The committee will have other business to tend to before long, and we will consider this. What's that? Oh, I'm sorry. Did we have one more? Yeah, we have another hands raised. We will be in recess until we reconvene on this matter, along with some other matters that will be before the committee. I do, just before I recess, want to thank the law department for correcting the record. It was news to me that the very publicized records that have been redacted were not actually redacted by the city at all. And I think that that's really important for public understanding of that matter. So I thank you for getting that clarification on the record here today. We're in recess.